Hello, this is product attorney Jason Ochs, and this is your Wyoming Health Watch for this morning, October 19th, 2019. I want to thank a lot of you for your comments that you've shared with me online regarding the Wyoming Health Watch. This is something new we're doing, trying to push as much value and information to people across Wyoming and throughout, frankly, the United States with information that's valuable, information that they feel is worth their while to listen to. So I took from many of the comments that I received a topic today that I want to talk about that seems to be on a lot of people's minds, and people were interested in finding out more about it. And this is the FAIR Act, the FAIR Act. The FAIR Act is an acronym for Forced Arbitration Injustice Repeal Act. This has gotten some publicity online. It's also gotten some publicity in the newspaper, though it's not been very much. And my hope is today on this podcast is not to convince you that yes or no on the act is right. I want you to decide that for yourself. What I'm here to do is provide you information so you can make an informed decision on the FAIR Act. The FAIR Act is an act that had circulated through the House of Representatives last week, seeking to make forced arbitration illegal via a contract in any sort of employment, consumer, antitrust, or civil rights dispute. Okay, and that's typically where you see arbitrations the most, although I have seen them many a times in the nursing home litigation context as well as in the medical malpractice context. I hope that the FAIR Act can act, if you will, as a beginning to even repeal forced arbitration in medical malpractice and nursing home settings. But I will take the small victories, if you will, as they come. What is an arbitration? An arbitration is kind of billed by corporations and other conglomerates that seek to require consumers and employees, etc., to agree to them. It's billed as a more effective and more expeditious and more efficient way to resolve legal disputes. If you sign a contract, and many times you don't even know that you're signing a contract, especially in the context that I've seen them in nursing home situations. But if you sign a contract with an arbitration clause, that requires you to submit any sort of legal dispute to an arbitration panel. And what does that mean exactly? That means you have to reach out typically to either an arbitration outfit that's in your city or in your town, or if you don't have an arbitration outfit in your city or town, you typically reach out to a retired judge that does arbitrations, or a settlement type mediation outfit that also has typically retired judges and retired lawyers who act as arbitrators. Now, one thing people don't realize is you have to pay these arbitrators, and they're not cheap, and they usually charge their usual and customary hourly rate for every single thing that they do on the arbitration, and that's part of the agreement. That's part of the deal. And it's not unusual, and I've had it happen many a times where arbitration individuals will charge anywhere between $250 to $400 an hour. Now, there are certain arbitration clauses that require a panel of 3 arbitrators, and that's not unusual. In fact, I'm seeing that more and more often. And what that means is the plaintiff goes out and hires his arbitrator, the defendant goes out and hires their arbitrator, and then the plaintiff and defendant both have to agree to a third arbitrator. And so now all of a sudden you've got 3 individuals billing their time, and it gets expensive very quickly. Let me give you an example. Typical in any sort of a legal case or even arbitration is you get on the phone at the outset of a case and you have what's called a scheduling conference. And you have the defense lawyer, the plaintiff lawyer, and whoever the arbitrators are. I had had an arbitration about 1.5 years ago, and we had to have a scheduling conference. And the scheduling conference is to set out dates for all the items that need to get concluded before the matter can be submitted to an arbitration. And the arbitration is it's a trial. It's a trial, but you're not trying it in front of a jury. You're trying it in front of the arbitrators, and often it happens in a conference room. It doesn't even happen in a courtroom. It never happens in a courtroom. I have seen some outfits, arbitration outfits that have kind of a quasi-looking courtroom in their offices that they hold arbitrations, but these do not happen in a courthouse, and there are not judges there making decisions, and there sure aren't juries there of your peers in the community making decisions. These are the arbitrators making the decisions. In any event, the scheduling conference sets out dates when things need to be completed by both sides, i.e. depositions and written questions and things of that nature, expert disclosures, and you got to disclose everything to the other side. Both sides have to disclose everything they intend to use for the arbitration, which is similar to trial. And in any event, back to this event that I had for a scheduling conference about a year and a half ago, we had 4 arbitrators on the phone. It was a scenario where we had to have not only the 3 that we had, but there was a 4th one because he was acting as an assistant for the main arbitrator. That wasn't something we agreed to, but it was just something that showed up all of a sudden when we were on the phone. This scheduling conference, which in my experience before a judge, scheduling conferences rarely last 30 minutes. Or more than 30 minutes. Judges who are familiar with this process and who've been sitting on the bench a long time get through this process very quickly. It's no nonsense. It's X, Y, Z, A, B, C. Here you go, and we'll see the next case. This telephone call scheduling conference with 4 arbitrators lasted 4 hours. And everybody had to comment about every little thing, and each of the arbitrators had to make their comment about every one of the dates, and it became the biggest mess of our time that I've ever had in a scenario. And then receiving that bill for all of the arbitrators' time after that 4-hour scheduling conference was like kicking somebody in the stomach. Number one, I've never received a bill after having a scheduling conference with the judge, nor would I. Judges are paid by, obviously, tax dollars. We don't have to pay anything for a judge if you go and have a legal dispute before a court. Arbitrators, you have to pay for it. And so this argument that it is expeditious and it's always an argument that it's far less costly, it simply hasn't been the way my experience has been with arbitrations. They are extraordinarily more costly in my experience. It is not unusual to rack up well in excess of $50,000 for the arbitration fees. And that's, you're not even getting to how much it costs to work up the case, how much it costs to pay your experts. This is on top of all of that, where you don't have that expense before a judge. You don't have to pay a judge hourly. You don't even have to pay, obviously, jurors hourly to sit there. There's sometimes a small jury fee that you have to pay. I don't think I've ever seen a jury fee more than $150 total. So number one, that's, in my view, one of the ways that arbitrations are not efficient and not expeditious, and certainly are not cost advantageous to a jury trial. Number two is just the realization that arbitrators make a living doing that. And if they start finding routinely for plaintiffs or consumers, employees, civil rights people, they will never have a big company or corporation agree to them in future arbitrations, which obviously has an enormous impact on their bottom line. And as a human being who is trying to make money to support their family and pay their mortgage, you can understand why this may be a consideration that otherwise is not a consideration that any judge in our entire United States has to worry about. So I do have concerns anytime I'm before an arbitration about the arbitrator that the defendant has agreed on. I always go and I do research on that individual before I agree, and I can't tell you how many times I've had to reject proposed arbitrators because they were proposed by the other side, and I've discovered that I had one matter where I discovered the individual they were proposing had found for this very specific defendant 8 times in a row the previous 24 months. No wonder they were agreeing to them. And if you are in arbitration or you will be going to arbitration, I would encourage you to talk to your lawyer about making sure they're doing their due diligence and researching these individuals when they're proposed before they agree to them, before anybody is then sitting in a position where they can make a decision that is paramount in your case. The other thing that is unique in an arbitration is there's no right to appeal. And so if there is some sort of inconsistency that occurs in your case, if there is some sort of a ridiculous evidentiary ruling that harms you in your case because this arbitrator has not been a judge who sat on the bench for 25 years and understands the evidence code. And I've seen this happen before. I had a very good friend have an evidentiary matter that would have never gone down the way it went down in the arbitration, but it destroyed his case. And as a result of the fact it was arbitration, there was no right to appeal. And he was stuck with the decision. Now, that can work both ways. Defense lawyers and defendants often threaten plaintiffs with the fact that they intend to appeal no matter what the verdict is before a jury, and they'll be waiting for 2, 3, 4 years until they see any money, even if they win. That is a threat, and sometimes that does occur. So in that vein, sometimes arbitration is nice. To limit a defendant from being able to appeal a plaintiff's verdict. However, I submit to you that in arbitrations, plaintiff verdicts are far more unlikely than a defense verdict. So, circling back to the FAIR Act, I mentioned it in the outset, where I've seen it be most problematic and frankly just most upsetting to me is in the nursing home context. You can imagine any adult child having to take their mother and or father into a nursing home. It's already a very unpleasant experience, to say the least. You're trying to make the best of it. You walk through a facility, they give you the tour, they have it all set up, you feel pretty good about it, you're not feeling good that you have to do this at all about your mom or dad, and they hand to you a stack of papers that you need to sign. You've already spent a good amount of time touring the facility. Your mom or dad is already being well taken care of, at least from your perspective at that time. And there is an enormous stack of papers that you know just by looking at this stack that it's going to take you hours upon hours to read all of this. And who has the time to sit there and read all of it while your mom and dad or dad is getting taken care of already in his or her room? And always hidden within these documents and these nursing home scenarios is an arbitration clause. And at least in Wyoming, and I did a lot of nursing home litigation in California, but most recently it's been in Wyoming. When these individuals come to my office and they want to talk about what happened and these horrific events that have occurred at a nursing home, I always ask them, please go get the documents you signed when you first agreed to have your mother or father admitted. And I always identify this arbitration clause, and it just pains me to see that when I share that there's an arbitration clause in the contract they signed, it is clearly obvious to me that this is the first time that they've been made aware that there was an arbitration clause. They obviously didn't know at the time, and it's easy to sit back and be critical of them if you're on the peripheral. I'm not. I always take the position that unless you're in somebody's shoes, try not to be critical. These are very vulnerable times when you're dealing with a nursing home situation with your mom and dad. I haven't had to experience that, but I assume at some point I'll have to experience it in the future, and I hope I'm as diligent as I would hope to be and review all the documents, and I certainly intend to be. Maybe when that time comes, there will be an amendment, if you will, to the FAIR Act, and they won't even allow these arbitration clauses. In any event, it's something to be aware of in nursing home context. I know Kaiser Permanente in California has a mandatory arbitration clause. We did a lot of Kaiser litigation when I lived in California, and it was always arbitration. You never were able to get out of that arbitration clause. There are some arguments you can make legally at times to get out of them. It's usually arguments of unconscionability, that there's no bargaining power that you have. However, the case law is not in favor of the consumer in this respect. I did win just last year a motion to avoid a arbitration clause in a nursing home case in Wyoming. It was a huge victory. We were extraordinarily happy about it. We felt the judge, who spent a lot of time and a lot of reflection and a lot of research on it, made the right call. He followed our arguments on it. And right after the order came out, the defendants, which is an enormous conglomerate, it was Kindred Healthcare, which is an enormous billion-dollar conglomerate that has nursing homes all over the country, not just Wyoming. They appealed it to the Supreme Court. our Supreme Court is notorious for being conservative, not in a political sense, but in an unwillingness to make tough decisions. And we went and argued it before the Supreme Court, and they reversed it and sent it back in and ordered that the arbitration clause be adhered to, that the arbitration clause be followed. And in spite of our trial judge, who had, in my view, a tremendous willingness to do the right thing, we ended up getting thrown back down, and we had to go through arbitration on that case. And thankfully, we still resolved that case in a very positive way for our client. But nonetheless, it added costs to the client. It changed the dynamics, and then the costs were added because we had to pay an arbitration panel that we never would have had to pay if we were in front of a judge. So it still happens, and it happens to this day. The FAIR Act went before the House of Representatives last week. It did pass 225 to 186, and as you can imagine, if you're listening to this, every single Democrat voted for it. 2 Republicans voted for it, and the remaining Republicans voted against it. It now needs to go to the Senate, and I do worry that it will not pass the Senate, but I do applaud the representatives in the House for giving this a first run. Often bills do not pass their first go-around, and I'm hopeful that this can grab some attention, that it can gain some traction, and with a little luck, we can remove forced arbitration in these sort of contexts of employment, consumer, antitrust, and civil rights. And with a little bit of God's grace, hopefully we can even get this to apply in medical malpractice and nursing home contexts in the future. As always, if you have any questions on this topic, if you want any more information on it, if you're curious, if your House of Representative voted for it or against it, you can certainly go online and find that. I was disappointed when I saw that my representative, which is Liz Cheney, Dick Cheney's daughter, voted against it, but I can't say that I was surprised. I do think that the FAIR Act is a step towards returning power to the people, as opposed to the corporations and the conglomerates. And I'm always in favor of acts like that, and it doesn't matter to me if they're Republican submitted or Democrat submitted. In any event, I'm optimistic that this is a first step and another way to ensure that vulnerable individuals aren't taken advantage of at that level. Thank you so much for listening. Again, this is product attorney Jason Ochs. This is part of your Wyoming Health Watch. If you'd like any more information on this topic, go to wyominghealthwatch.com. Please also feel free to submit any questions you'd like through the Wyoming Health Watch website. I read each and every comment and question that comes in. I appreciate all of you who have done it so far. Thank you so much. Have a great day.